And thanks to the organizers for inviting me to this conference. I need to see my own slides. That's why I just had to change that a little bit.
Can you do it from here?
It's okay.
Or
yeah,
you
it's
can
okay.
speak from there if you prefer.
I think I'll try from here. That
yes,
should be okay. I'm also not going to introduce myself. That has been done already in writing. But in order to clarify the program, let me put it in legal terms. The Dublin regulation has not got an expanded scope of application, neither functionally nor personally. I have not been relocated to the Netherlands, as the program suggests. I just found out last night that you have affiliated Aarhus University to the Netherlands, and also has the Netherlands not yet occupied Jutland. So I am still from Denmark, and that of course also gives a particular background to my reflections on the common European asylum system, because it doesn't apply to my country. I will try to pretend not to be biased by that fact. Well, I think I need to move actually, because I can't see.
Yes, please do.
I haven't got a print of this, so forgive me sitting down here. Having 20 minutes to reflect on both the achievements, the limitations, and the potential of the common European asylum system is quite a demanding task. I cannot go through all the instruments, I cannot go through all the regulatory levels, but I'll try to do both in brief, actually. I think in order to understand what goes on, and also actually following very much Guy's approach from the presentation just before, we need to grasp the interaction between the different regulatory levels. Legislation is only one thing. Another thing is formal transposition, and even more important is the actual interpretation and the concrete application by member states. And finally, we have the various judicial bodies involved here, which I'll come back to. But before going into this, let me just mention that there is also an issue of, we could say, functional delimitation of the common European asylum system. That is the issue of access to protection. And that may, in more than one sense of the word, be beyond reflection. At least I'm not going into detail with that today. But also in practice, the various non-arrival devices and the various pushback practices may actually be beyond reflection, in the sense that they may often be outside the scope of effective monitoring, because we essentially do not know what happens. We pretty often these days see reports on pushbacks, in particular on pushbacks, I would say, of those who manage to approach the common European asylum system in geographical terms. But we don't see many reports about the non-arrival devices, which operate even further apart from EU territory. That we shouldn't forget. Of course, talking about the common European asylum system in this very city of Dublin, it is difficult not to start with the Dublin regulation, which is one of the, I think at least in Denmark, we have ministers saying that this is the cornerstone of the common European asylum system. It does apply to Denmark, actually, as the only one of the components. I think I'm not among those who argue right as of law for asylum seekers or refugees to choose their own country of asylum. I don't think there is such a right under international law, but there is a right of protection. And therefore the crucial point concerning the Dublin regulation, in my view, is not that it actually forcibly relocates or allows for the forcible relocation of asylum seekers. That may well be at least legally acceptable, although sometimes personally unacceptable. But the real problem is, of course, that the underlying premise of mutual confidence is far from being well-founded. The whole problem is, in my view, to put it briefly and easily, that the Dublin regulation was put in place as the first step towards harmonization, rather than as the end solution or the follow-up on substantive and procedural harmonization. insofar it is the principle of mutual confidence. It's even now in the court's reasoning. It's a principle, not just a premise which can be tested, but it's a principle, and that is in many ways more of an illusion than it is being well founded. That has some bearing also on the judicial monitoring, of course, to which I shall also come back. A few remarks on the various elements of the common European asylum system. Many people would tend to say that the Procedures Directive, at least the 2005 version, is the worst of the harmonization instruments. I tend to subscribe to that view. It has a complex structure, as all you who have used it or tried to come to terms with it will know. It has many incomplete standards, it has too many exceptions and far too many derogations, and finally it has insufficient safeguards in appeals. Some of these shortcomings have been remedied in the recast direction from last summer, which doesn't have to apply yet, only in 1.5 years. So we still have to live with the 2005 directive for quite a while. And even the 2013 recast directive has not solved all the problems. Let me see, what can I do? That was it. Thank you. To continue with one of the next elements of the system, the definitions in the Qualification Directive, I think this was in many ways helpful. Not only to avoid erroneous interpretation in certain new member states, but certainly also to effectively harmonize certain crucial issues of interpretation in some of the very old member states. We all know there were problems with, in particular, I guess, Germany and France as regards the non-state agents of persecution. Those problems should have become solved by way of the Qualification Directive. I say should have because I don't know how it is operating in practice. There may be issues of evidence which can serve to counteract the harmonization, but still the abstract interpretation has become much better. The internal protection alternative was problematic in the 2004 directive. It has become at least better, maybe acceptable in the recast directive. The particular social group also has been very helpfully harmonized. That is probably also one of the most important improvements by way of this directive. And finally, of course, subsidiary protection, although not fully solved. To begin from the bottom of this slide, the problem is basically that Article 15 of the Qualification Directive does not take into account the fact that the Strasbourg Court of Human Rights may, and actually has already, expand the scope of non-refoulement to go beyond Article 3 of the European Human Rights Convention. That cannot be included in the scope of protection under Article 15 of the Qualification Directive, if people are protected due to the risk of unfair trial, for instance. That is not a basis for subsidiary protection so far. I don't know whether that was ever discussed in the recast discussions. I never heard of it, actually. And it was not included in the Commission proposal in any event. There are also certain issues concerning non-state actors of protection, and not least importantly, at least at the theoretical level, there is an issue of the schizophrenic approach to the nature of refugee status. On the one hand, the directive states recognizes that the recognition of refugee status is declaratory. On the other hand, the directive itself actually allows for an additional operation which is granting status, which in practice means that it also allows for application of additional de facto exclusion grounds in Article 14, which is, in my view, in violation of the Geneva Convention. Briefly on protection standards, there were quite significant problems, at least in terms of harmonization, in the first reception conditions directive. Many of them have been solved, although in a very sort of political, pragmatic way. Instead of waiting 12 months to get access to the labor market, now we have to wait 9 months. The proposal was 6 months, as you know, a very wise compromise, obviously. Yet there is still some reason, maybe even more reason than before, for concern about the possibilities of detention under these rules, because the finally adopted Reception Conditions Directive actually allows, while it was a kind of black box before, it now has actually codified a rather wide possibility of detention to detain asylum seekers for the sole reason of applying for asylum. In the Qualification Directive, protection standards for those recognized were, of course, suffering from the problem of quite significant differences between the entitlements for convention refugees and beneficiaries of subsidiary protection. Now I was silenced. Okay. They have been solved largely in the recast directive. In particular, of course, most importantly maybe as regards the access to the labor market, where the previous Article 26 was very dubious, and that has simply been solved now by granting the same rights to both categories of beneficiaries of protection. Now, having gone through the instruments, I'll go to the level of interpretation and application, and that is the judicial level or the judicial function within the whole system. That is being operated, I think, in an interesting mix between political and purely judicial bodies. The first step of monitoring is, of course, the commissions, that of the Commission, being the guardian of the treaties and therefore also monitoring the actual compliance of member states with EU law obligations. So far, it seems that this monitoring function is being carried out only at the very formal level. We have seen some infringement proceedings initiated by the Commission, but to my knowledge, mostly for failure to formally transpose instruments. Although the Commission is actually following up and issuing reports on the application of the various directives, I don't think that the Commission is very keen to go to the Luxembourg Court in order to have issues of interpretation or erroneous interpretation addressed by that court. That instead takes place at the initiative of domestic courts, which of course sort of presupposes that the domestic court is aware of the problem and is prepared to accept that it needs guidance. In other words, the system of preliminary rulings does not protect against sort of entire systemic deficiencies, including the domestic courts. If they don't see the problem, or if they don't want to have advice on how to solve it, then there will be no solution provided by the Luxembourg Court. On the other hand, I think we have seen important contributions by the Court of Justice of the EU, at least at 3 levels. First, as regards interpretation. Even in my country, being beyond the scope of the directive and the judgments, we have been, or the Court of, the Board of Appeals has been inspired by one of the important judgments from the Court of Justice, the one from September 2012 on religious conversion. And that is, of course, because, as Guy said before, it is based on human rights considerations, inspiring the interpretation of the EU acquis by including basic human rights in the relevant area. Insofar, I think the 7th November 2013 judgment on sexual orientation could be helpful to the same effect, although I know there has been criticism of that. But still, I think the interpretation guidelines provided by the court has been largely helpful. The El Ghaffati judgment was interesting because I think the opinion of the Advocate General was partly based on a kind of misunderstanding of asylum law, yet still it was actually quite good to have a kind of fresh air put into the asylum system, because he sort of introduced this level of violence, or level of general violence approach, which inspired the court definitely, and which is a helpful operational approach to such cases. In terms of procedural standards, one might say that this Luxembourg court has been maybe less daring, just as the harmonization instruments are less ambitious in that regard. It's interesting to note the different ambitions of the different levels of harmonization. I'm thinking here of, in particular, of the judgment in HID from January last year, which went quite to some length to avoid questioning the structure of the Irish appeal system. Let me put it diplomatically that way. And also recently, the judgment in the Abdullahi case, which is actually commented upon in the 4th article on the EDAL website. That is Maria Hennes's very insightful comment on the Abdullahi judgment, which could, in the interpretation of the scope of judicial review in Dublin proceedings, which could there have gone a bit further, one would say, and at least it could have drawn more specifically on the Charter of Fundamental Rights, which was invoked before the court but was not addressed at all by the court. So this is one example here. So I think so far we haven't seen so much inspiration and solutions from the Court of Justice in terms of solving procedural issues. And in my final slide, which I'm then not going to use really, I would look a bit to the potential. And I think that one of the potentials is actually to draw more on general principles of EU law, which can now be largely translated into standards of the Charter of Fundamental Rights. That would not least be the case in terms of procedural standards, where the principle of effective remedies or effective judicial protection under Article 47 of the Charter could be helpful to solve also some of the remaining problems with the Procedures Directive, even in the recast version. Finally, of course, the Court of Justice of the EU has been extremely helpful in solving one of the fundamental flaws of the Dublin system. I'm here, of course, referring to the NS and ME and others judgment from 2011, which set the standard of systemic deficiencies. That was in one way helpful, and I think it was quite logically argued by the court in that judgment, but I think they took that threshold too far in this Abdullahi judgment, as Maria Hennessy is convincingly arguing in this EDAL article. We couldn't disregard the fact, however, that the Luxembourg court got quite a good deal of help from the friends in Strasbourg when it came to the controversial issue of Greece, because the MSS judgment had paved the way for the abstract findings in the NS and ME judgment by way of the MSS case earlier 2011. And looking finally to the Strasbourg court, I would like to say that I think there has been an interesting interaction between the two courts when it comes to the to the development of the entire European asylum system, partly going beyond the EU in formal sense. We saw one important development in the Dublin cases. Another one is about the scope of subsidiary protection, where in the first place the EU Court of Justice clarified that the Qualification Directive goes well beyond Article 3 of the European Human Rights Convention by way of the literacy concerning armed conflict. Then there has been an interesting sort of taking issue, or whatever it was, beginning with the Soufi and Elmi judgment, in which the Strasbourg court tried to inform the Luxembourg court that they could do the same thing with the European Human Rights Convention, which is perhaps right in one sense, but still may also maybe be an unhelpful way of developing the interaction between the two instruments, as long as the European Human Rights Court had still maintained that the Article 3 protection against refoulement was apparently more limited than what would seem to follow from Article 15C of the Qualification Directive. Finally, looking to the potential, I think that there would be maybe the primary potential for improvement in the years to come would be to hope for and rely on the judicial developments, helping the interpretation of the instruments and not least the integrated approach to some of the standards that are also affected by the Charter of Fundamental Rights. At the same time, however, I think that the development also has to be accompanied by a more modest reliance on the principle of mutual confidence. I think that the court went well too far in that regard in the Abdullahi judgment of 10th December 2013, and that it may well be necessary to get back to realities in that regard. Not least due to the fact that the Greece scenario, the systemic deficiency, seems to be spreading in the southern and southeastern part of the Union. So therefore there may be new challenges, and it may be very problematic for effective protection to wait until the chaos has become so complete as was the case in Greece, either in June 2009 when the UNHCR warned, or in January 2011 when the Strasbourg court at long last realized the problems.
Yes. Thank you.
At the same time, I would emphasize that the Common European Asylum System has, of course, enhanced protection standards in many ways, not only in new member states, but as I said, in particular maybe in terms of the substantive definition, certainly also in some of the old member states, and even in non-member states or states beyond the Common European Asylum System, such as my own, because not only have some of the approaches to the definition become harmonized formally in the directive, but also some important and crucial interpretive problems may have to be solved on a current basis. And there, the interpretation by the Court of Justice of the EU of the directive, in particular the Qualification Directive, which is based, of course, on the UN Refugee Convention, can be helpful far beyond the EU member states, actually. To make full circle before I close, of course, there is also a need to keep a constant eye on the issues of access. One of the approaches to this could be what Guy was referring to about the inclusive or extensive interpretation and application of Article 1 of the European Human Rights Convention. We may have a similar discussion coming up. There has been recently strong arguments advanced in favor of the view that the EU Charter of Fundamental Rights has no territorial limitation, which may be an interesting challenge to extraterritorial operations of EU bodies, may be coordinated by Frontex. I also think, although it is formally outside the Common European Asylum System, that it is necessary to think of compensating measures for the fact that we still have non-arrival policies and probably cannot get rid of them. I'm afraid that it has to be necessary to also think of, you may say, regional protection programs, whatever. I know it is problematic, it's controversial, but as long as we cannot do away with transnational or extraterritorial or pre-arrival control measures, then I think there is also a challenge to try to take heed of the realities, which are that many would-be refugees, many genuine refugees, are actually left unprotected due to these devices. And that may, of course, cause challenges to the EU well beyond the scope of the common European asylum system, but certainly not unrelated to the fulfillment of the protection objectives of that system. Thank you for your attention.
Thank you very much.